call, as well as several motions that you filed up, that you noticed up. One of them does require some testimony. That was the motion to suppress the chemical test results. Your filing the motion triggers the prosecutor's burden to establish that that search was taken properly. Is there any opening statement you want to make, Mr. McLeod, about your motion to suppress the chemical test results? And you'll have an opportunity to argue after the testimony as well. Any opening statement you want to make?
Well, I just received an email from Julie Rattel. I don't know if she's a court administrator or clerk.
She works in the prosecutor's office.
Okay, I just received an email from her on Friday with the warrant that was never found in discovery or anywhere. It just turned up Friday magically, I guess. Okay. So I'd like to open with that.
Today, we were doing a BUI patrol. Other COs notified that there was a boat with expired registration. Subsequently, we found out that the defendant was intoxicated while he was operating the vessel, and that led to the arrest of him. Once he had exited the vessel, I noticed that he had to use the post on the dock for his balance to get out of it. He stumbled and swayed back and forth along the dock and up the ramp of the boat ramp. While talking to him, I observed slurred speech. I noticed that it took him about 10 seconds just to put on one of his sandals. Myself and Officer Listenfeldt, we advised him that he was going to be under arrest for BUI and asked him to exit the vessel that he was in. He refused. Officer Listenfeldt got inside of the vessel with him. The defendant pulled away from Officer Listenfeldt. A scuffle erupted. He put his arms in front of him so that way he couldn't be cuffed. Time I pulled out my taser, I took the cartridge off so that I could use the dry stun option. And then finally, Officer Listenfeldt was able to pull his right arm behind.
Whole lot of courtroom delusion. Our defendant? He's convinced that filing mountains of paper and quoting fake constitutional buzzwords will somehow erase a DUI. Or in this case, a BUI, boating under the influence. But here's where it gets good. Not only does he challenge the evidence, he insists the warrant itself magically appeared out of thin air. You're about to watch a judge with the patience of a saint calmly dismantle every baseless claim. And the ending? Let's just say the only thing sinking faster than his defense is his credibility. Buckle up, because this is one of those hearings that reminds us, you can't out-argue the law with vibes.
Well, I've already shown that the warrant's invalid. It's got unsigned documents that are supposed to be accompanying it. So I would say that it should be upheld that this warrant was invalid. It was executed improperly. It was not served on me. It was not given to me by release. It was not found in discovery with 3 requests. So it's very convenient that it turned up Friday.
All right, thank you, Mr. Juliet.
Just briefly, just based on I understand the court has to make a credibility assessment here on whether the officer did in fact type up a search warrant and serve it on the defendant. He certainly had probable cause to draw blood. That's common procedure when somebody refuses a chemical test. The defendant displayed signs of intoxication, which led to the arrest for boating under the influence. He refused a chemical test when offered one. Based on the observations of the officer, he had probable cause to submit for a search warrant for blood. He did that. He typed out the affidavit, and it looks like, to me, it looks like it's electronically signed. On defendant's exhibit 3, he said that he served it on the defendant, left it in jail. So I would ask the court to deny the defendant's motion.
All right, well, the motion was to suppress the results of the blood test for alcohol in Mr. McLeod's body because the blood was drawn without a warrant. Based upon the officer's testimony in People's Exhibit 1, that blood was in fact taken pursuant to a search warrant issued by a magistrate. So therefore it didn't violate the 4th Amendment. The complaint and affidavit and warrant that the defendant's referring to are the charging documents for the issuance of the charge. It doesn't have anything to do with the drawing of the blood. There was a warrant for the drawing of the blood, and it was drawn. And the officers testified that they did leave the warrant and tabulation and affidavit.
Here it is, the sovereign citizen special. Accuse the court of hiding documents, hint at a grand conspiracy, and pretend it's all a gotcha moment. He's claiming a search warrant magically appeared, as if the prosecution pulled it out of a hat mid-trial. But the truth? The system doesn't move on mysticism. It moves on paperwork. Also, notice how he refuses to use the free attorney sitting right there, because apparently Google University taught him enough to challenge Michigan criminal procedure solo. What do you think, viewers? Misplaced confidence or pure courtroom comedy? Drop your verdict below.
It's not being timely held or validly waived. Any additional argument you want to make on that motion?
Yeah, the waiver was supposed to be signed by both parties. That's state law, and only the prosecuting attorney signed it. And then neither my defense attorneys or myself signed it. I'm just curious how that transpired.
Hey, Mr. Juliet?
Just briefly, I did submit a response to this, and I did research the case law on this. I did confer with district court. It doesn't look like a probable cause conference was held, but I did read the case cited by the defendant in his motion that dealt with the failure to hold a preliminary examination within the statutory time period. That doesn't warrant dismissing the case. If anything, that would call for a remand, perhaps to district court.
Remand back to district court.
But in this case, and in the case that I cited, there has to be some showing of prejudice by not holding the preliminary exam or probable cause conference by analogy. In this case, there was a preliminary exam that was held and it was bound over by Judge Visnot. So I don't think there can be any prejudice by failing to hold a probable cause conference.
Officer's testimony is about as clear as it gets. Expired registration, clear signs of intoxication, refusal to cooperate, and even a brief scuffle. Now, you'd think after getting tased on a boat, most people would have a moment of clarity. Not this guy. He's still fully committed to the laws don't apply to me narrative. And look at how professionally the judge lets it all unfold. There's no mockery, no yelling, just calm, methodical fact. Finding. Meanwhile, our defendant's building his next doomed argument. You can almost feel the tension, like watching someone walk straight into a legal buzzsaw in slow motion.
Prove probable cause at that hearing. They have to prove it at the prelim. The probable cause conference, it's maybe not a great name for it, but that conference is just to address, are we running a prelim? What issues might there be at the prelim? Should the defendant be released from the jail pending the prelim?
But does it not still need to be waived by both parties?
It does, but the fact that it didn't has no prejudice to you. So defendant moves to dismiss the case on the ground the probable cause conference was not timely held and that it was not validly waived.
Actually,
I'm making my ruling now, Mr. McCall. Defendant relies on People v. Weston involving the failure to timely hold a preliminary examination for an in-custody defendant. His reliance is misplaced, however. In People v. Crawford, the Michigan Supreme Court held that the Weston remedy must be invoked prior to the preliminary examination being held. In any event, Weston did not address probable cause conference, which did not exist at the time. The probable cause conference is to address possible plea negotiations, bond matters, and the scheduling of the preliminary examination. Defendant has shown no prejudice, even if a probable cause conference was never held and not validly waived. Moreover, defendant exercised his right to the preliminary examination. Dismissal is an extreme remedy and defendant has not shown that it is warranted.
Boom. The first motion gets denied. Textbook Fourth Amendment logic. A warrant was issued, signed by a magistrate, properly executed, and left at the jail. Whether he personally received it doesn't matter. This is where sovereign citizens always trip up. They confuse procedural preference with constitutional violation. The judge handled it perfectly. Clear reasoning, no theatrics, no loopholes. One motion down, 9 to go. And spoiler, it doesn't get any better for our sea captain of battle.
So you exercised a right and it was held. So there's no harm to you. You exercised a right. All right, now you filed a second motion to suppress based on lack of sufficient basis for law enforcement officer to make contact. I'm not entertaining oral argument on that motion. It's just a repeat motion. Defendant moves to suppress evidence and dismiss the case based on a lack of sufficient basis for the law enforcement officer to make contact with him and a lack of evidence of his intoxication or impairment. This motion essentially raises issues that were argued in defendant's first motion to suppress. As explained previously, the officer had legitimate grounds to approach defendant based upon his observation of defendant operating a marine vessel with expired registration. Upon initial contact, the officer detected signs of impairment. Therefore, both his initial contact and his investigation were entirely lawful. Accordingly, defendant's second motion to suppress is denied. Mr. McLeod, you also filed a motion to reconsider the reconsideration. That's not really authorized in the court rules. I'm not entertaining oral argument on that. Defendant moves for reconsideration of this court's recent order denying his motion to reconsider this court's denial of his.
Now this next motion is classic sovereign filler. He claims the case should be dismissed because the probable cause conference wasn't properly waived. Let's translate that. He's arguing that a meeting didn't happen exactly how he wanted, so the entire case should vanish. Judges see this all the time. Minor procedural quirks being blown up into constitutional violations. The prosecutor calmly explains, a probable cause conference isn't even required to continue a case when no prejudice exists. The defendant wasn't harmed, wasn't detained, and already got his hearing. But he's not hearing that. He's locked into the belief that form over facts will win.
The burden of demonstrating a palpable error by which the court and the parties have been misled, and that a different disposition must result from correction of the error. Moreover, a motion for reconsideration which merely presents the same issues ruled on by the court, either expressly or by reasonable implication, will not be granted. Defendant essentially raises the same issues that have already been briefed and argued. Defendant has failed to meet its burden of demonstrating a palpable error. Accordingly, the motion for reconsideration is denied.
I think you're failing to notice or recognize the lack of jurisdiction that you have in this.
Well, that brings us to you filed three more things, and I want to address those today because today was the motion cutoff. So you've got a
And
motion.
I don't consent to that anymore either. I need more time to file these motions.
Nope, today's the motion cutoff. You filed three more. I'm going to hear them today. You have a motion for dismiss for lack of jurisdiction. We've addressed the jurisdiction previously.
You don't have jurisdiction.
I already ruled that I did.
You
This
can't rule that
motion-
you have your own jurisdiction.
This motion is denied. This court does indeed have subject matter jurisdiction over the charges by law.
Personal or subject
and personal.
jurisdiction. I object.
Your objection is noted and your motion is denied. All right, you filed a motion for disclosure of bonds. I don't even understand what you're talking about. in that
I don't
motion.
know. Somebody else handled that.
What's that?
I don't understand.
You don't understand it either? Okay.
Here's the beauty of experience. This judge has seen every trick in the book. He cites case law, explains the difference between conferences and hearings, and drops the hammer. Dismissal is an extreme remedy, and you haven't shown prejudice. Translation: no harm, no foul. Case moves on. It's moments like this that show the gap between actual legal training and YouTube legal myths. You can almost hear the judge thinking, I've got 30 cases on the docket, and this guy wants to argue over a missed meeting